All right, good afternoon, class.
Good
I'd like to welcome you to today's class. My apologies, we've mixed about 2 or 3 classes, and this is due to my involvement in the ongoing examination as the exam officer. So it's been difficult combining the 2 assignments together. Well, thank God that there's no exam ongoing at the moment, so that gives us room to have our class this afternoon. All right, so we're just going to pick up from where we stopped, and we are looking at interpretation of statutes. We're considering the common law rules, that is, the various canons of interpretation. We've taken on the literal rule. We've looked at the golden rule, and now we want to take it off from that spot. So, do we have anybody in the house who can give us a summary of what the literal rule of interpretation is all about? And another person to also give us the summary of what the mischief rule as a canon of interpretation is all about. Erioluwa, yes, you can have the floor.
Good afternoon, sir. Sir, for the literal rule, it's just saying that that the judiciary or the court does not have any business in using his own discretion to give out the rule. If a rule says this is it, then the court should go about to say the law as it is, as long as the law is not ambiguous. The court should state the law as it is. However, because of the nature of cases, it has been what is the word now? It has been, doubted sometimes that the literal rule has not solved some issues. So it has had its hiccups, but then it's just saying that the court does not have any business in changing the statutes given by the legislature. That is it, sir.
Thank you very much. That's a very brief and precise summary. Okay. Then let's look at the mischief rule. Anyone?
Hello, sir.
Yes, please.
Yes, please.
Okay, sir. On the mischief rule, or the golden rule, on the golden rule, sir, it was illustrated in the case of Big versus Smith, where Park B established the rule,
Can you
stating
speak
that.
up
Can
a
you speak
little
up a
bit
little bit
so that we
so
can
that
hear
we can hear
you?
you?
Sir, I want to speak on golden rule, not mischief rule. Golden rule.
Oh, sorry,
Oh,
I've not
sorry,
called
I've not
mischief
heard the
rule. It's
people.
golden
It's
rule.
golden rule.
Right.
Right.
Okay, sir. So golden rule was enunciated in the case of Beck versus Smith, where Park B established the rule of interpretation, stating that the literal rule is good and is helpful, but at times where the law is, first of all, is inconsistent with it, at times where the letters of the law or what the law provides stands to be inconsistent with the intentions of the legislators that propounded the law, and at times when the law is ambiguous or vague or obscure, the legislature can the judiciary, sorry, can interpret the law with an intent or with the aim of bringing forth the intent of the legislators. And Lord Denning, as well as another Lord Simon, made it clear that when the judiciary is embarking on this, that is interpreting the law to bring forth the intentions of the legislator, they must not go too far. There is a limit to how far they can go. In the words of Lord Simon, the court it is not the duty of the court to outside um something that their discovery is strictly limited. Their voyage of discovery is strictly limited. So that's basically the um purpose of the mischief sir.
All right. So,
Sorry.
yeah, thank you very much for your contribution. Now, if I may ask, do you really think that this mischief rule should be uh, probably allowed to stay as a canon of interpretation? Because from what we have seen, there is, maybe because of some of the disadvantages attached to the deployment of the mischief rule, is it something that should be allowed to stay in view of the fact that it is believed that the plain words as used in every legislation should be engaged and should be interpreted as plain as they are? Can I have anybody speak to that? Anybody? All right. You should be able to speak to such, because sometimes you may just find yourself having to answer that question in an examination condition. But giving it a trial here may give you leeway to what you are expected to do. All right, so let's take it off from this point as we consider the mischief rule. Please, Oluwole Muyiwa David, can you please stop what you are doing on our screen? Thank you. So we look at the mischief rule as the third canon of interpretation that we are going to be considering in this particular class. Now, in construction of the provision of a law or a statute, the issue of the legislation and the mischief it was designed to prevent must be considered, since the purpose of every interpretation is to discover the intention of the legislature from the word used. Now, I gave an example some time ago in the course of this class, and I said there was a time that kidnapping became very rampant in our community. And then the legislature went to action to see how the laws on kidnapping can be reviewed for a particular purpose. What purpose? The purpose was simply to prevent the continuous spread, or the fact that kidnapping was becoming very rampant and there was need to reduce it to the barest minimum. That was one of the reasons why the legislature went into action. Now, if there are reasons like that, there are also sometimes where there are reasons why the judiciary or the legislature when a law is made and that law is made to address particular mischief or points.
But I see I was going to arrange that place.
Okay? So there is always sometimes a particular mischief that a legislation, that is a law, is meant to address. And in doing that, usually the intent of the legislature is put into consideration. So, what is the error that a particular rule or a particular law seek to correct? That's on one hand. What is the intention of the legislature in terms of correcting that error? All of that are usually seen in the words used or engaged by the legislature. So, simply put, the mischief rule of interpretation is one of the canons of interpretation that is primarily used by the court to know the intention of the legislature. And this particular rule of interpretation came from what we call the Ejusdem case. Ejusdem is Heydon. Ejusdem case that, came to be in 1584. And the purpose of this mischief rule is to see how the mischief can be remedied so that, of course, the law is able to meet the purpose of the legislature, or why the legislature has, put up this particular law or statute. So now, under this particular rule, there are some things that we can refer to as elements of the mischief rule. And when you are talking about the element of the mischief rule, the court has a duty to consider some things in the course of doing their interpretation. But of course, in the case of the literal rule of interpretation, all the court needs to do is to interpret the words as they appear in the law. Why the golden rule deals, with departing from whatever it is written on the face of it with the intention of achieving justice or to prevent ambiguity or maybe ambiguity. Let's just put it that way. So these elements therefore include that the court need to consider what the common law was before the particular statute was enacted. This is the process of trying to know the intention of the legislature. Then also, what was the mischief or the defect that the common law did not address? This is another question that the court will need to ask. That what was the mischief or the defect that the common law did not address? The first one was that what was the common law before the statute or the law was made? The third is what remedy did Parliament provide through the statutes? And then the fourth one is what is the true reason for the remedy? The courts will have to consider these four questions in order to be able to do justice to the case that is before it. So basically, before we delve into it, the mischief rule allows the court to depart from the literal meaning of the word used in a statute. If doing so will best serve the reason behind the law. Of course, this may be similar to what we discussed under the golden rule of interpretation. But of course, the end point of every judicial action is justice. So the court usually seek to know how the purpose of the law can be achieved. Then, when a statute is being interpreted and the present state of the statute can lead to ambiguity, one of the reasons for the deployment of the mischief rule is to see how the gaps, the loophole, the ambiguity in a particular law can be addressed. Now, I'll give you some examples of how this rule of interpretation was used. Now, in the case of Smith versus Hodges, Hughes, Smith versus Hodges, reported in 1960, the court applied the mischief rule to interpret the Street Offences Act of 1959, even though the statute prohibited soliciting in the street. Prostitutes soliciting from a balcony were still found guilty because the act aimed to prevent solicitation in public places. Now, this case of Smith versus Hodges is that there was a particular law that prohibits soliciting in a street. Now, when you look at it from the literal meaning, it means that the only time an individual can be guilty of soliciting in the street is when he or she is on the street. But when you have a street, on either side of the street, you have houses. So there was a prostitute who stood by a balcony. After all, I am not on the street. I am by the balcony of my house, even though the balcony is facing the street and the street is facing the balcony. So I can solicit from my balcony, and then it does not amount to street soliciting. But the court did not agree with that. The court looked at the reason for the prohibition of solicitation and said, what was the purpose? The purpose was to get rid of situations where individuals will advertise themselves with the purposes of making private gain and corrupting public morale. So the court found the individual guilty of the fact that even though you are not on the street, but you are in the front of your house facing the street, therefore you are guilty of soliciting in the street, because the said apartment where you are soliciting is just by the street. But how the judges arrive at that is that the judges went outside the literal appearance of the law to ask what purpose. Because even in the face of it, in our normal time, when laws are made, we try as much as possible to circumvent the law. How do we circumvent the law? On the top of my head, I'm trying to look for, okay, let me give you an example. which I believe that everyone in this class may have experienced or may have been caught in the web of committing that offense. At the time, we were still making use of paper attendance in the Faculty of Law here. The rule is that when you come to class, you sign your name on the attendance. That signing your name on the attendance is an indication that you were present for that lecture. So it means that the only time your name can be on the attendance is when you were present for that lecture. But what the students started doing? Students formed the habit of making their friends to write their names for them. That is an attempt to circumvent the law. And this does not apply to only that area. There are several areas of our lives in the society where people tend to circumvent the law. I give you another example. You are not supposed, when you are driving your car on the road, you are not supposed to carry anything that will shoot out of the normal compartments of your vehicle. If you carry something that is bigger and is shooting out either to the back or to the side, it can cause obstruction, and consequently, it can cause accidents on the road. Then you now choose to say, okay, I want to carry something that will shoot out of the vehicle. Instead of carrying it during the day, I will carry it at night, when the police or whatever may not be visibly on ground. If you are caught in that web, whether you do it in the night or in the daytime, the purpose of the law is to prevent likely incidents that may occur by reason of the way you have loaded your vehicle. So, the law will always, at every point in time, look at the intention of the legislature when they are making the law. And that's why in the case of Smith and Hodges, the court found the prostitute soliciting from the balcony guilty of soliciting in the street, even though the said prostitute was not soliciting on the main streets. Now, I give you another example. In the case of Royal College of Nursing versus DHSS, this is another example where the mischief rule was also used. The case of Royal College of Nursing versus DHSS, reported in 1981. In this particular case, the rule was used to determine whether nurses administering abortions under medical supervision violated the Abortion Act of 1967. The court ruled in favor of allowing the practice, considering the purpose of the act. Now, the purpose of that Abortion Act is to manage abortion. Manage abortion in what sense? There are some abortions that are permitted. Maybe if the fetus is likely to bring danger to the life of the mother, or there are other circumstances. But what the law wants to achieve is to prevent indiscriminate abortions. So if the abortion is done under the supervision, of maybe under medical supervision, then it may be seen that the purpose is not just to prevent it, but is to ensure that it is done when necessary or as allowed by law. Now, later on, we'll compare the literal rule of interpretation, the golden rule of interpretation, with the mischief rule and see how they narrowly different from one another. So basically, the mischief rule aims to determine the purpose of a particular statute, and then to cure whatever reason that law was made, and to ensure that the law achieves its purpose. Now, let's look at another case, a Nigerian case of IBWA Ibua Limited versus Imano Nigeria Limited. IBWA Limited versus Imano Nigeria Limited. In this case, the Supreme Court held that the court's duty is always to make such construction that will suppress the mischief and advance the remedy. But this will only arise if there is a latent ambiguity in the words used in that law. Otherwise, the literal rule is always to be embraced. One thing you can see from our various conversations on literal rule, on golden rule and mischief rule is that these other canons of interpretation will only be deployed when the wordings used in a particular law are not clear, or where they can bring about injustice. Then what the court is expected to do is to prevent that injustice. And that is when the mischief rule or the golden rule of interpretation or other sub rules that we also consider in the course of this class can be deployed. So what it means, therefore, is that the literal rule is the most elementary rule that should always be used at every point in time. The only time the court of law as a court of justice is allowed to depart from this rule is when, again, I repeat, when the law as it appears may bring about injustice or can lead to absurdity, then the court will be forced to consider other options in order to do justice. So, therefore, the literal rule of interpretation is the most elementary rule of construction that will be applied in statutory interpretation, because at every point in time, it helps to, state the law as they are. And then, in order for justice to be achieved. So, but of course, we cannot take away the other rules that have been provided because of their usefulness to humanity. Now, we will discuss another case in order for us to have better understanding of what we are talking about in the course of this lecture. We will look at the case of Ifezue versus Mbaduga. Okay? We'll look at that case of Ifezue versus Mbaduga. I'll spell that for you in case you want to do further reading on that. Ifezue is spelled I-F-E-Z-U-E versus Mbadiba. Mbadiba is spelled MBA, MBA, DUG, HA. Okay? Ifezue versus Mbadiga. Now, what was in question in this particular case was section 258 sub 1 of the Constitution was what came before the court for interpretation. So the section provides, and I quote, every court established under this Constitution shall deliver its decision in writing not later than 3 months after the conclusion of evidence and final addresses, and finish all parties to the cause or matter determined with duly authenticated copies of the decision on the date of the delivery thereof. So here, the rule says that when a course of action is when a case is concluded, that the judge must deliver its written judgment not later than 3 months. So meaning that if the court concludes a case today, every party, the 2 parties that have submitted, giving all their arguments, and then they are awaiting their judgment. The rule says that the judgment must be delivered not more than 33 months after that. Now, what was now the issue before the court here? The question here was whether non-compliance with the above provision violates the trial. That was the question in issue. Then, His Lordship Aniogu JSC, or I'll call Aniogula JSC, Justice of the Supreme Court, who read the lead judgment, said that the provision was aimed at a situation whereby some judges became notorious for long adjournment of judgments, leading to a deprivation from them of the advantage of forming fair impression of witnesses and the evaluation of evidence. Now, what the court was trying to say here is that the reason why the law says that you must give your judgment not later than 3 months, the court is saying that it is to stop the habit of some judges who will finish their case now in maybe February 2025 and wait till December 2025 to deliver judgments. So what the court was saying there was that the law did not say that at all costs judgment must be delivered, within 3 months. The court said in its reasoning that all that the law was trying to achieve is to curb, the excesses of judges. Now, let me bring it home to something that you may understand. In this university, before you are allowed to take any examination in a particular course, the university rules provide that you must meet at least 65% of attendance. Now, what it means is that if the literal rule is to be applied, once you fall less of that, then you are not qualified to write the exam. But what is the reason behind that rule? The reason behind that rule is that many students may choose not to come to school, stay away, gallivanting, just as we are in this class now. There are some of your colleagues who are in the markets, some are even in the movie houses. Maybe some of you that are listening to me now, you are even at the eatery, some of you are at the salon, you are just enjoying yourself. Some even logged in and they walked away from the class. But if the rule of the university is you must come to class, the rule believes that your physical appearance in that class will compel you to listen to what the lecturer is saying, so that you can learn by force and be able to understand at least what you are being taught. So if the mischief rule is to be applied on this rule, the court will want to look at why did the university set attendance rule in the first place. Anybody can tell me that the reason is to ensure that students come to class. But believe me, even with this rule, some of you still do what you like. But of course, the law has compelled many to always find their way to attending lectures, which is good for us. That, oh, we have done what we're supposed to do, and therefore you are supposed to learn. So, in this particular case of Ifezwe and Mbaduga, the courts, when the court deployed the mischief rule, it was aimed at, clearly saying that, yes, the rule has provided for a certain days, but that is not the most important. What is most important is that judgment should be delivered promptly, so that parties can benefit from their struggle. Because the court also believes that if you listen to litigants now and you do not sit down to write the judgment, you may forget some of the things that the witnesses said. Because the judge is not a superhuman. He cannot remember everything except God, who can remember everything that we have said since the beginning of this day, or since we were born. But for human beings like us, they cannot. So the court believed the rule was aiming at the judges delivering their judgment on time, so that you'll be able to evaluate, the evidences that have been put before the court. And that's why some of us, when we remember something, instead of just saying, okay, I will put it in my head, we quickly write it down. It is in order for us so that we will not forget, to clearly do justice to what we are supposed to do. So, in this case, the Supreme Court ultimately hold that the word shall, as used in that section, is mandatory with regard to delivery of judgment within 3 months. Even though the court still had to go with the wordings of the legislation as contained there, the court still upheld the fact that that shall means that you must comply, you must deliver your judgment within 3 months. But we have moved away from the literal meaning to see how the intention of the legislature can be achieved. It's not about complying with rules that matters. Rather, it is getting the purpose for the making of the rules. Now, let's do a little comparison with other rules. mischief rule and other rules that we have discussed. Number one, the literal rule focuses strictly on the ordinary meaning of the word. It does not concern or bother itself with what whosoever was thinking when they were making the law. What was important is the wordings of the statute, because they believe that the legislature has provided their intention in writing. So therefore, you have to interpret it as it appears. What about the golden rule? The golden rule modified the literal meaning to avoid absurdity. Okay? It modified the literal rule to achieve clarity, to avoid absurdity. Then what about this purposive approach? It's a broader version of the mischief rule, focusing on the general purpose of the legislation. Like the case I just discussed, in this case of Ifeswe versus Mbaduga, the court stressed that even though this law is in existence, that what the court was after, or what the rule was after, is to see how judges can write their judgment when the cases or the fact of the cases are still very much fresh in their memory. Okay? So that is all about the mischief rule of interpretation as one of the major canons of interpretation. With that, we will have concluded dealing with the major canons of interpretation, and we will move on to look at other principles or aids, what we call aids to interpretation. Aids to interpretation. But if you have a question at this point, I would like to take them before we build on what we have done so far. I'm open to take a question. Yes, please.
Sorry, sir. Can we have the link to the case between Infeswa and Baduga?
Yeah, I do not have the citation here, but you can Google it. You may be able to get, or you go to the library. Oh, you are not on campus. Okay, but you can, if you Google it, you definitely find something to show the content of what the case is all about. Okay. All right.
Okay,
so
sir.
then let's move on to what we call other principles.
I have a question, sir.
Or aids to interpretation. Of course, everything still boils down to interpretation and how the best can be achieved from the law that has been made. So therefore, we submit that outside the above major canons that we have looked at, there are other minor rules of interpretation in some quarters, which we have referred to as aids to interpretation. And this includes the following. I'm going to list them, and then we can take them one after the other. The first one is the Ejusdem generis rules. Ejusdem generis rules. It is spelled E-J-E E-J-U-S-D-E-M, Ejusdem. The next word is generis, Generis. Ejusdem generis rules. We also have, okay, let's be taking them one after the other. Let's explain what we mean by Ejusdem generis rule as another canon of interpretation. This phrase simply means of the same kind or genus. It simply means of the same kind or of the same class. You have a better understanding when we explain further. What this rule says is that the rule is to the effect that that where particular words of the same class is followed by a general word, the meaning of the general word will be limited to those things similar to the class earlier enumerated. Okay, I'll repeat that again. This rule of interpretation is of the effect that where particular words of the same class is followed by a general word, the meaning of the general word will be limited to things similar to the class of things earlier enumerated or earlier listed. So what the rule means is that the general words should be interpreted to include only items of the same nature as the specific words. I'm going to give you an example in this class so that you can understand. If a statute provides thus, and I read to you, cars, trucks, motorcycles, and other vehicles. I'll repeat that again. Cars, trucks, motorcycles, and other vehicles. The other vehicle is a general word. Why? Which we also refer to as a generis. The particular word here are motorcycle, trucks, cars. If you come home, we say keke napep. Those are the specifics. The phrase other vehicles would be interpreted to mean vehicles similar to cars, trucks, and motorcycles, and not aeroplane or boats, because those aeroplane and boats, they do not move on the road. But what it means, therefore, is that since we have mentioned cars, we have mentioned truck, we have mentioned motorcycle, the other vehicles can include, one, can include keke napep, it can include bicycle. What other thing do we have now that falls within that class? Okay, let's just limit it to that class. So the Ejusdem generis rule applies to interpretation is to the effect that when particular words are listed and the general word is used at the end, that the meaning of that general word can be gotten from the particular that have been listed. We gave an example of cars, trucks, motorcycle, and other vehicles. The other vehicles should be interpreted not to include aeroplane, not to include both, not to include I don't know what they call this thing in English now. There is this thing that the traditional people use where somebody can disappear from point A and appear in another place. I think
Teleportation.
Yoruba call it ofe. So it will not include ofe, it will not include aeroplane, it will not include boats, it will not include ship if we
Or
use that.
broom.
So it also applies when you say ferry, you say ship, you say vessel, and other means of transportation. That other means of interpretation, being a general word, should be construed to mean means of transportation that operates on water. I don't know if someone is following me. The purpose of this rule of interpretation is to help manage classes of words so that you do not sorry, I lost my thought there. So that you do not go outside what is will further do harm to what is being treated. So that is one of the roles that Ejusdem generis plays. Now, let me give you another example here. Example is taken from section 1, sub 1 of the Rent Control Act of 1965. Section 1, sub 1 of the Rent Control Act of 1965 defines premises as, listen, the law defines premises as the following. Building of any description occupied or used by persons for living or sleeping or other lawful purposes. That's the way the law defines premises. I repeat again, that law, the Rent Control Act of 1965, defined premises as building of any description occupied by person for living or sleeping or other lawful purposes. The court, in the case of Noscitur versus Boan, was faced with the question whether premises used partly as a living accommodation and partly as a nightclub fell within the definition as premises used for other lawful purposes. In this case now, we have houses that some people use as their residential, and then at night they simply fold, no, they use for commercial. At night they simply fold their whatever and convert it to their living, to where they live, where they sleep. So in that case, the case of Noscitur versus Boan, the court refused to give the phrase any wider interpretation beyond the particularized kind of premises and concluded that it meant premises used for purposes similar to living or sleeping. It therefore excludes nightclubs. Nightclubs is not a place where people live. It's a place where people go to enjoy themselves. It may be possible that some of the people or one of the persons listening to this class is somewhere like that. The person is, of course, not in a class, but you know, you can give it any other interpretation. So, the word premises was described as building of any description occupied or used by persons for living or sleeping or other lawful purposes. Then the question you may want to ask is that, is having or operating a nightclub an unlawful purpose? That is a question that you may need to answer on your own. But what the court did in interpreting this is that other lawful purposes does not include nightclubs. The reason why the court was probably forced to hold that view was because the definition I talked about that the place must be used for living or sleeping. So, if a nightclub is inclusive, a nightclub is not a place where you sleep, but it's a place of enjoyment. Let me give you another example of a case where this rule was deployed. In the case of R versus Edmondson, R as in letter R, capital R, versus Edmondson. Edmondson is spelled Edmundson. R versus Edmondson is in a case reported in 1859. The term other person in a statute listing father, mother, guardian was interpreted to mean someone with similar parental responsibility. Now, let me check whether this class is following me. Let me provide this rule like this. And then the class need to tell me those who falls within the class of other persons. So I'm going to list father, mother, guardian, and other persons. So if you are to interpret other persons, which individuals falls within this class? Anybody?
People that are not family.
People that are
A
what?
grandmother. A grandmother.
Grandmother, yes.
An uncle.
An uncle can stand in place of
An auntie,
An
a
auntie.
cousin,
Siblings,
an
a
auntie. Yes.
cousin,
Just give me 1
a
minute.
neighbor, a cousin. Huh? Like siblings. Cousins are like distant, but they are still family though.
Yes.
Yes, mom.
Okay.
People, someone that fulfills the role of providing
Of
shelter,
family.
feeding, and anything that a father should do or anything that a mother should do. Schooling, provision of food, shelter, and co.
Well, is it Obio Keke now has given us another wider meaning to say that anybody who provides for all of those things, maybe school, provides for shelter and all that. But one of the good things about all this rule is that it helps to aid doing justice. So here, the thing is other persons. It will mean other persons who stands in place of local parentis. That is someone who can play the role of a father or a parent. So other persons, will a teacher include other persons?
No, sir.
No.
Teacher will not, right?
Yes,
No,
sir.
sir.
Yes, sir.
Will a porter fall with
Only
No,
if the
sir.
porter is family.
a porter will not fall into
Yes.
all right. Okay, let's look at another case. Let's look at another case so that we'll take that example and then we can move on to other canons. In the case of Attorney General versus Brown, a statute refers to wharfs, docks, piers, and other places, was held to apply only to places related to maritime structures, wharfs, docks, piers, and other places. Will a bus stop be part of this class?
No.
Which other places can fall within this class?
Sorry, sir. Can you come again with the question?
In this case of Attorney General versus Brown, a particular law refers to wharfs, like as in Apapa Wharf, what we call wharf, wharfs, docks, piers, and other places. What other places what other name or other place can we identify to fall within that class of other places? So I asked, can
Water pot.
the bus stop
Yes.
and the bus stop form that class?
No.
No,
No,
sir.
sir.
No, sir.
Which
No,
other
sir.
example?
A water pot,
What?
A pot.
a seaport, a seaport.
A seaport, yes.
You
Oh,
can have the harbor.
harbor, yes. I think I'm satisfied that this particular rule is well understood. Thank you very much for those wonderful contributions. Let's move on. That's very good. Let's look at another canon of interpretation known as Noscitur sociis. These are not English words. Noscitur is spelled Noscitur. I repeat again. Noscitur is spelled Noscitur. Associate. Noscitur is one word. A is one word, then you give a space and move to sociis. Sociis is spelled SOCIIS. So Noscitur is one word. A is one word. Sociis is one word. So we have Noscitur sociis rule. We get that?
No, sir. Please, can you come again?
Okay.
Okay.
Noscitur is spelled Noscitur. Noscitur. There is another word is which will be pronounced as a. The next word is sociis. SOCIIS. So that is Noscitur associal rule. If you are not speaking to us, mute your mic so that we are not distracted. I hope we have gotten that spelling now.
Yes,
Yes,
sir.
sir.
No, sir.
Okay. So now let's look at what this rule is all about. The Noscitur associate rule postulates that a word is known by the company it keeps, meaning that the meaning of a word is derived from the company it keeps. Let's bring it home. When you have a group of armed robbers, and then you now say that there is somebody in that gang who is a pastor, or you go to a beer parlor. People that you see in beer parlor are people who have come to enjoy themselves, probably who take delight in drinking. So everybody you see there, you are likely to group them as people of the same mind. That's what this rule is saying, that the rule says that a word is known by the company it keeps. In other words, the meaning of a particular term is in a statute may be, and is quite often ascertained by reference to the word associated with them in the statutes. Where two or more words which are susceptible of analogous meaning are coupled together, then we say it comes under Noscitur associate. It's just like when you try to give a meaning to a word by reason of the sentence that word is. And that's why we say that even though you may not know, if you find a new word, for example, in what you are reading, you may probably not consult your dictionary and you will still know the meaning of that word in context because of where that word is. Okay? Because it is believed that the word that is surrounding it gives meaning to the word itself. And then it is easy to understand. Okay? So, what it means is that the meaning of a particular word can be gotten from the company that it keeps. And this, in literal, the English meaning of Noscitur associate is a word is known by its associates. A word is known by its associates. That's the meaning of Noscitur associate. So, meaning that when you want to determine a word, you determine the meaning of the word by the context of the word that surrounds it. So, if you take your mind back to Ejusdem generis rule, which says that when you list cars, you list truck, you list keke napep, you list bicycle and all that, and other vehicles, that means that other vehicle is referring to those particular words that have been listed. So you can see that Noscitur associate is also saying that the meaning of a particular word can be deduced from the surrounding words. And simply means that words can be, the meaning of a word can be determined from the context it is used. Now, let me give you an example. If a law refers to banks, financial institutions, and vaults, I repeat again, banks, financial institutions, and vaults, the word vault should be interpreted as referring to vaults used for financial purposes, e.g., bank vaults, not just any type of vault, not burial vaults, but rather vaults that are used for financial purposes. You get the point now? I repeat that example again. If a law refers to banks, financial institutions, and vaults, the word vault should be interpreted as referring to vaults used and not any other vaults like burial vaults, but rather a vault that is used for keeping of financial items. Now, I'll give you another example or another fact about this canon of interpretation. The Noscitur sociis rule was applied to the construction of the Offenses Against Persons Act. That is a law. Offenses Against the Persons Act of 1833. It's a law of England. What does this law stand for? It makes it a felony, that is an offense, to shoot at or to stab or cut or wound any person. That's what the law is all about. So it is an offense for you to shoot, for you to stab, for you to cut or wound any person. So the word wound was held to be restricted by the word which preceded it, which means that any wound that you're talking about here must be wounds inflicted by an instrument. Okay? Look at the words that were used before. Shoot at. Gun was used, right? Stab. Either a knife was used. Cut. You can use cutlass to cut. Cutlass is a tool. And when the word wound now follows, it means that for any other word to fall into that class, it must be a wound that originated from an instrument. So, meaning that to bite off a finger or a nose, or to burn the face with maybe vitro, was not to wound within the meaning of the act. So, what will conveniently fall into that class is any injury caused by an instrument. So the question is whether your teeth is an instrument. It's now for us to determine. Okay, so that is for that. Let me give you a case where this rule was used. In the case of Foster versus Carson, Foster versus Carson, as in Casson. In this case, a statute requiring explosives, machines, tools, and implements to be stored in a safe place was interpreted to mean explosives. Explosives, machine, tools, and implement to be stored in a safe place was interpreted to mean explosives similar to the items listed, rather than just any dangerous item. So, this rule of interpretation will simply allow you to get the meaning of a particular word from the other surrounding word. Okay, so what makes it different from Ejusdem generis? Class, what makes the Noscitur sociis rule different from Ejusdem generis rule? Anybody? As we begin to wrap up the class. Anybody? Class, what is the difference between Ejusdem generis rule and the Noscitur sociis?
For the Ejusdem generis rule,
Can you
is where
speak up
there's
a
like a list
little?
of specific
Hello,
items
sir.
followed by a general term. So the court focuses. Huh?
Yeah, I would like you to speak louder.
Okay. For the Ejusdem generis rule is where there is like a list of specific items followed by a general term. So the court focuses on limiting the general term to the category of those specific items. Then for the Noscitur sociis rule, that one is like there's only one ambiguous word or phrase that needs to be clarified, and they use like the context of the neighboring words to explain it.
Beautiful. Yes, somebody else wanted to say something. You want to add something? All right, I think I'm fine with that submission by that individual. So, do we have any question? Because we are going to stop there for today, and then we take it off from there in our next class. Any question?
Excuse me, sir. Please,
Yes,
can we
please.
ask questions from previous classes?
Well, let's try.
Okay, sir. We're having a discussion in the group
Please, can you
chat
speak up a
about.
little?
Okay, we're
Hello,
having a
sir. Can you
discussion.
hear me?
Someone is speaking, please.
We're having a discussion in the group chat.
Can I ask my question?
Hold on, someone is speaking.
We're having a
Okay,
discussion in the
sir.
group.
The man speaking,
We're
I
having
can
a
barely hear you. So the woman that wants to ask a question, please ask.
Okay, thank you, sir. Maybe immediately after David can ask this question. I wanted to ask if these aids of interpretation have been used, or like there's any evidence that they help, or the legislature take cognizance of them when making laws. Like an example, like the legislature knowing about the Ejusdem generis rule, we try to, I don't know, try to make their laws in cognizance of that rule. So I want to know if there's any evidence of the legislature taking cognizance of any of these aids of interpretation.
Well, I really cannot say. Basically, the work of the legislature is to provide laws that are clear enough. And that was what we started with. And that even the perfection of man will always meet with some flaws. So that it is that flaw that all these rules, makes effort to cure. Usually, the legislature don't make laws for errors. They don't make law to create ambiguity, but claims of parties to those actions or individuals is what now necessitates the court to delve into the actual meaning of the world. But it's not that the lawmakers that we have are not aware of these rules. They are aware, but it doesn't determine what they do because they are only supposed to make plain law. I mean, they are supposed to make laws that will be plain enough to understand. Okay? All right. So with that, we stop here because another class is to start in about a minute from now. So thank you very much for listening. Do enjoy the rest of your day. Bye.
Okay. Thank you, sir.
Thank you,
All right,
sir.
sir. Thank you, sir.
Attendance.
Thank you, sir.
Attendance.
Yeah, sir. What
Thank you,
about
sir.
attendance? The child is disabled.
Thank you, sir.
Big arrest.
Please, so I'm lost. So was this the? This was not where he stopped in the last class.